Good morning and welcome to Minors Counsel and Introduction regarding relevant code sections and case law for 2021. We're first going to start with the Family Code section 7861 that discusses appointment of private counsel for minor children. Family Code section 7861 states the court shall consider whether the best interest of the child requires the appointment of counsel. If the court finds that the interest of the child requires representation by counsel, the court shall appoint to represent the child whether or not the child is able to afford counsel. The child shall not be present in court unless the child so requests or the court so orders. In addition to Family Code section 7861, we will be looking at Family Code section 3150A. If the court determines that it would be in the best interest of the minor child, that the court may appoint private counsel to represent the interests of the child in a custody or visitation proceeding, provided that the court and counsel comply with requirements set forth in Rules 5.240, 5.241, and 5.242 of the California Rules of Court. We will be going over those rules of court during this session. California Rules of Court 5.24 discusses the appointment considerations, the request for appointment of counsel, orders appointing counsel for a child, the panel of counsel eligible for appointment, complaint procedures, termination of appointment. After California Rule of Court 5.240, we will look at California Rule of Court 5.241. 5.241 will discuss the determination of counsel's compensation, determination of ability to pay, payment to counsel, and parties' inability to pay. When you have a moment, you can look at these rules of court in detail that give you plenty of guidelines as far as the rights and responsibilities of minors counsel. Rule 5.24 discusses the appointment of counsel to represent a child in family law proceedings. The appointment considerations that the court must take into effect and consideration are the issues of child custody and visitation are highly contested or protracted. The child is subject to stress as a result of the dispute that might be alleviated by the intervention of counsel representing the child. The court also has to consider when appointing minors counsel if the counsel representing the child would be likely to provide the court with relevant information not otherwise readily available or likely to be presented. The court will look at if the dispute involves allegations of physical, emotional, sexual abuse, or neglect of the child. It appears that one or both parties or parents are incapable of providing a stable, safe, and secure environment. If counsel is available for appointment, who is knowledgeable about the issues being raised regarding the child in the proceeding. The court has to consider the best interest of the child as it appears to require independent representation and not able to be set forth by either party or their counsel. And if there are two or more children, any child would require separate counsel to avoid a conflict of interest. The request for the appointment of counsel is rather broad. The court may appoint counsel to represent the best interests of a child in a family law proceeding on the court's own motion or if requested to do so by a party, the attorney for a party, the child or any relative to the child, a mediator under Family Code section 3184, a professional person making a custody recommendation under Family Code section 3111, 3118, Evidence Code section 730, or Code of Civil Procedure section 2032.010 et sec. A counsel, a district attorney, a city attorney, or a city prosecutor authorized to prosecute child abuse and neglect or child abduction under the state law can also request minors counsel. A court-appointed guardian ad litem or special advocate, and then the catch-all, any other person who the court deems appropriate. The orders appointing counsel for a child must have certain language included in them. The court must issue orders, written orders, when appointing and terminating counsel for a child. The appointment orders must specify the appointed counsel's name, address, and telephone number, the name of the child for whom counsel is appointed, and child's date of birth. The appointment orders may also include the following, which tend to be very helpful for any attorney that is appointed: the child's address, if appropriate, issues to be addressed in the case, so the minors counsel is able to narrow down the issues that the court wants to be presented, tasks related to the child that would benefit from the services of counsel for the child, responsibilities and rights of child's counsel, counsel's rate or amount of compensation, allocation of fees payable by each party or the court, the source of funds and manner of reimbursement for counsel fees and costs, allocation of payments regarding counsel's fees to one party subject to reimbursement by the other party, the terms and amount of any progress in installation or installment payments, and the ability of the court to reserve jurisdiction to retroactively modify the orders on fees and payments. There will be more detail regarding compensation of the attorney that we will discuss later during this section. The panel of counsel eligible for appointment. Each court may create and maintain a list of panel of counsel meeting the minimum qualifications of this rule for appointment. If a list or panel of counsel is maintained, a court may appoint counsel not on the list or on the panel in special circumstances, taking into consideration factors including language, culture, and the special needs of a child in the following areas: child abuse, domestic violence, drug abuse of a parent or the child, mental health issues of a parent or the child, particular medical issues of the child, and educational needs. If the court maintains a panel of counsel eligible for appointment and the court appoints counsel who is not on the panel, the court must state the reason for not appointing a panel counsel in writing or on the record. Any lists maintained from the court might appoint counsel should be reviewed at least annually to ensure that those on the list meet the education and training requirements. Court should ask counsel to annually update their information and to notify the court if any changes would make them unable to be appointed. I did review our court's list and panel, and they were updated last year of March 2020, probably after this minors counsel training had ended. So I'm glad to see that everyone is following through with putting themselves on our panel. Complaint procedures. By January 1, 2010, each court must develop local court rules in accordance with Rule 10.613 that provided for acceptance in response to complaints about the performance of the court-appointed counsel for a minor child. I was able to go through our local rules and did find that that section is our local Rule 5185, Court-Appointed Counsel Complaint Procedures. Letter A states the purpose of this section is to establish a procedure for addressing complaints against court-appointed counsel for a child. Complaints regarding the conduct and the procedures employed by counsel appointed for a child be in writing and will be handled by the judicial officer to whom the case is assigned. The court will determine what action, if any, to take, including whether the complaint should be referred to the appropriate professional licensing board and if counsel should be removed from the minors counsel appointment list. Written notice of the outcome will be sent to the complainant within 90 days of receipt of the complaint. Then we go back to termination of appointment. On entering an appearance on behalf of a child, counsel may continue to represent that child until the conclusion of the proceeding for which counsel was appointed, relieved by the court, substituted by the court with another counsel, removed on the court's own motion or request of counsel, or parties for good cause shown, or the child reaches the age of majority or is emancipated. Regarding the section that says the conclusion of the proceeding for which counsel was appointed, a lot of times these cases have many review hearings, and so it's not necessarily clear when that proceeding that you were appointed for has ended. So if you feel at some point in time towards the end of the case that your work has been completed, it's always wise, just as a point of practice, to ask to be relieved at the end of that hearing. The court can always appoint you further down the road if they feel it is necessary. We will also be going over California Rules of Court 5.242. You will start to see that a lot of this information is duplicative and repetitive, which is good. We're lucky that we have a state legislature willing to provide so much detail as to what needs to be done, what our rights and responsibilities are regarding representing children, and that the Judicial Council makes sure that these are strictly followed. Rule 5.242, qualifications, rights, and responsibilities of counsel appointed to represent a child in family law proceedings. The purpose is that this rule governs counsel appointed to represent the best interests of the child in a custody or visitation proceeding under Family Code Section 3150. The general appointments. To be eligible for appointment, a counsel for a child must be an active member of the state bar in good standing, and also have professional liability insurance or demonstrate to the court that he or she is adequately self-insured and meet the education, training, and experience requirement of this rule. The education and training requirements that were effective January 1, 2009, before being appointed as counsel for a child in the family law proceeding, counsel must have completed at least 12 hours of applicable education and training, which must include all of the following subjects. 1, statutes, rules of court, and case law relating to the child custody and visitation litigation, representation of a child in custody and visitation proceedings, special issues in representing a child, including the following: various stages of child development, communicating with a child at various developmental stages and presenting that child's view, recognizing and evaluating and understanding evidence of child abuse and neglect, family violence and substance abuse, cultural and ethnic diversity, and gender-specific issues. The effects of domestic violence and child abuse and neglect on children, and how to work effectively with multidisciplinary experts. The annual education and training requirements are effective January 1, 2010. To remain eligible for appointment as counsel for a child, counsel must complete during each calendar year a minimum of 8 hours of applicable education and training in the subjects listed in Section C above. The education and training required that addresses subjects listed in C may be applied toward the requirements of this rule if completed through a professional continuing education group, an educational institution, a professional association, a court-connected group, or a public or private for-profit or not-for-profit group. A maximum of 2 hours may be self-study under the supervision of an education provider that provides evidence of completion. Counsel may complete education and training courses that satisfy the requirement of this rule offered by the education providers by means of video presentations or other delivery means at remote locations. Luckily, we are prepared for that this year. And such courses that are not self-study within the meaning of this rule. Counsel may serve as an instructor in education and training course that satisfies requirements of this rule and may receive 1.5 hours of course participation, credit for each hour or course instruction. All other counsel may claim credit for actual time he or she attended the education and training course. There is an exception regarding experience requirements. Persons appointed as counsel for child and family law proceeding must have represented a party or a child in at least 6 proceedings involving child custody with the preceding 5 years as follows. At least 2 of the 6 proceedings must have involved contested child custody and visitation issues in family law, and child custody proceedings in dependency or guardianship cases do count, but not for more than 3 of the 6 required for appointment. Courts may develop local rules that impose additional experience requirements for persons appointed as counsel for a child in a family law proceeding. There are alternative experience requirements. Attorneys and counsel who do not meet the initial experience requirement, if in letter F, may be appointed to represent a child in a family law proceeding if he or she meets one of the following alternative requirements. Counsel must be employed by a legal service organization, government agency, private law firm that has been approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings and be directly supervised by an attorney in an organization, an agency, or a private law firm who meets the initial experience requirements. Also, B, an attorney working in consultation with an attorney by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings, or if they demonstrate substantial equivalent experience as determined by local court rules or procedure. The compliance with appointment requirements require that a person appointed as counsel for a child must file a declaration with the court indicating compliance with the requirements of this rule no later than 10 days after being appointed and before working on the case. Counsel may complete the Declaration of Counsel for a Child regarding qualifications, Form FL322, or any local forms that the court has provided. The attorney must also notify the court within 5 days of any disciplinary action taken by the state bar, stating the basis of the complaint, the result, and notice of any reproval, probation, or suspension. Probably one of the most important parts regarding Title V rules is the rights of counsel for child. These should be read carefully and taken note of. Counsel has rights relating to the representation of a child's best interest under Family Code Section 3111, 3151, 3151.5, 3153, and Welfare and Institution Code Section 827, which include the right to 1. Reasonably assess the child. 2. Seek affirmative relief on behalf of the child. Notice to any proceeding in all phases of that proceeding, including a request for examination affecting the child. Take any action that is available to a party to the proceeding, including filing pleadings, making evidentiary objections, and presenting evidence. The right of counsel is also to be heard in the proceeding, which may include presenting motions and orders to show cause and participating in settlement conferences and trials, seeking writs, appeals, and arbitration. Access the child's medical, dental, mental health, and other care records and school educational records. Inspect juvenile case files subject to the provisions of Welfare and Institutions Code Section 827. Interview school personnel, caretaker, healthcare providers, mental health professionals, and others who have assessed the child or provide care to the child. However, the release of this information to the counsel does not constitute a waiver of the confidentiality of the reports, files, and any disclosed communications. Counsel also has the right to interview mediators, subject to the provisions of Family Code Section 3177 and 3182. Counsel may receive reasonable advance notice of the right to refuse any physical or psychological examination or evaluation for purposes of the proceeding that has been ordered by the court. Counsel also can assert or waive any privilege on behalf of the child, seek independent psychological or physical examination or evaluation of the child for the purposes of the proceeding on approval by the court, receive child custody evaluation reports, not be called as a witness in the proceedings, and request the court to authorize release of relevant reports or files concerning the child represented by counsel of the relevant local child protective services agency, and receive reasonable compensation and expenses for representing the child in the amount that the court will later determine. We have a local rule that I did look up for Riverside County, and it is local rule 5175, court-ordered child custody evaluations. As a part of this local rule, Section E, it does state ex parte communication. Absent a stipulation to the contrary, there shall be no ex parte communication between the attorneys for either party and a court-appointed child custody evaluator, or between the child custody evaluator and the court. Minors counsel, however, may exchange both oral and written ex parte communications with an evaluator. No attorney or party to the action shall provide the child custody evaluator with documents pertaining to the case without first providing the other side and an attorney of record for the child a copy of the document. There are responsibilities that go along with being minors counsel. Counsel is charged with the representation of the child's best interest. Therefore, you have to present the child's best interest to the court. A lot of times that will be in conflict with what the child wants. A lot of minors counsel will put both what they believe the child's best interest in their declaration and their evidence, and they will also represent to the court what the child's wishes are if that is something that is deemed to be appropriate by minors counsel. The role of the child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in a manner appropriate for the counsel of the party. If the child so desires, the child's counsel must present the child's wishes to the court. Counsel's duties, unless under other circumstances, is inappropriate to exercise and include Family Code Section 3151. Interview the child, review the court files and accessible relevant records available to both parties, make any further investigation that counsel considers necessary to ascertain the facts relevant to the custody or visitation hearings. If you have any questions on how to obtain the file or the records or the declarations that have been filed with the court, you can always contact the Family Law Clerk's office. They're very good at providing minors counsel with a copy of the entire file, which should be reviewed prior to your next court hearing. Counsel must serve notices and pleadings on all parties consistent with the requirements for parties. Counsel may introduce and examine witnesses, present arguments to the court concerning the child's welfare, and participate further in the proceeding to the degree necessary to represent the child adequately. Your role is to be an advocate, an attorney. You will still handle the service and the filing of documents and presenting evidence just as if you were representing one of the parents. In any case in which counsel is representing a child who's called to testify in the proceeding, counsel must provide information to the child in an age-appropriate manner about the limitations on confidentiality and the possibility that information to provide the court may be on the record and provided to the parties in the case. What this means is that you have to explain in language that the child understands that what they say is not a secret and it will not be confidential, and it will likely be disclosed to the court and both parents. They need to be made aware of that. Allow but not required the child to state a preference regarding custody or visitation. What that means is you don't have to ask, and you should not ask really, who they want to live with. If the child wants to disclose that to you in a way that they feel is comfortable, that's certainly something that you can provide to the court as information. But if you do ask the child who they want to live with, they might not be ready to answer that, and they might not want to be put in that position either. So it's always best to let the child just naturally disclose that if that becomes relevant. Provide procedures relevant to the child's participation, and if appropriate, provide an orientation to the courtroom where the child will be testifying. And again, that's if the child will be testifying. If the child is going to be testifying, then it is nice for the child to go and visit the courtroom and see where they're going to be sitting, or possibly that they won't be sitting in the courtroom at all, possibly being interviewed on the record in chambers. It's nice to give them an orientation so they know what to expect ahead of time. And inform the parties and in the court about the client's desire to provide input. It is your duty to let the judge know if the child does want to address the court. Other considerations. Counsel is not required to assume the responsibilities of a social worker, of a probation officer, a custody evaluator or mediator, and it is not expected to provide non-legal services to the child. It is very easy to slip into those rules when you're dealing with minor children, so you should always keep that at the forefront of your mind. Subject to the terms of the court's order of appointment, counsel for a child may take the following actions to implement his or her statutory duties in representing a child in a family law proceeding. Number 1, interview or observe the child as appropriate to the age and circumstances of the child. In doing so, counsel should consider all possible interview or observation environments and select a location most conducive to conducting a meaningful interview of the child and investigating the issues relevant to the case at that time. When I served as minors counsel, it was my preference to meet with the child at the school. It seemed like a neutral location, a safe location for the child, something part of their daily life and activities. What I would do is I would go to the schools ahead of time, present my court order, present my ID, present my bar card, speak with the administrators to let them know what my purpose and intent was. And oftentimes they were very happy to have someone involved to speak with a child. I would keep my interviews to a minimum 30 minutes, so not to disrupt their school classes. In a manner and to the extent consistent with the child's age, level of maturity, and ability to understand and consistent with the order of appointment for the case. This can be really hard for a lot of attorneys to speak to a third grader as to their case, but sometimes it's in the best interest of the child if you use words that they understand, and absolutely ask follow-up questions to make sure that they're really understanding what you're trying to communicate. Explain to the child at their first meeting counsel's role and the nature of the attorney-client relationship, including confidentiality issues. Advise the child on a continuing basis, if possible, of courses of action and the risks and benefit of each course of action. This does get challenging with a small child, but there are ways that you can inform the child in language that they understand what certain actions will result in certain courses of action and benefits. Actively participate in the representation of the child at any hearings that affect custody, visitation of the child, and attend and participate in any other hearings relevant to the child. In doing so, counsel may, as appropriate, take positions relevant to the child on legal issues before the court. Seek and advocate for services for the child. Prepare for any hearings. Work to settle contested issues and define trial issues. That section is often overlooked, and I do see parties filing mandatory settlement statements and not involving minors counsel in the MSC hearings. So always be aware of the calendar for your case as well. Prepare witnesses, including the child if the child is to testify. Introduce and examine witnesses on the child's behalf and cross-examine other witnesses. You will also be able to make appropriate evidentiary objections, review court files and pertinent records, prepare motions in advance, present arguments in court, prepare trial briefs, and request appointment of separate appellate counsel. Throughout the whole process, you are going to behave as though you are an attorney in a court of law. So you have the same rights and responsibilities as the attorneys for both parents in the case. You also have conduct throughout continuing in independent investigations and discovery to protect the child's interest, which might include obtaining necessary authorizations for release of information. A lot of times the court will provide that to you in advance so you don't have problems down the road. Reviewing the child's social services, mental health, drug, alcohol, medical, law enforcement, education, other records relevant to the case. Review the court files of the child and his or her siblings, cases-related records of social service agencies, and case-related records of other service providers. You do have the right to contact attorneys for the parties and non-lawyer guardians ad litem, CASA representatives, and other service professionals. Additionally, you have the ability to contact and meet with the child's parents, legal guardians, or caretakers with the permission of their attorneys. Oftentimes, minors counsel forget that if the parents do have their own attorney of record, you need to contact their attorney to get permission in advance. You have the right to interview witnesses that the parties have called or witnesses that you feel are relevant. You have the right to review photographs, video, audio recordings, and other evidence. You have the right to document the results of these investigations. Monitor compliance with court orders as appropriate, including provisions for effectiveness of any court services. Promote the timely progression of the case through the judicial system. You do have a voice, and if you see that the parties are delaying and making this longer than it needs to be, you do have the right to present that information to the court. Investigating the interests of the child beyond the scope of the proceeding and reporting the court other interests of the child that may need to be protected by the institution or other administrative or judicial proceedings. However, counsel is not responsible for instituting those proceedings or representing the child in them unless expressly appointed by the court for that purpose. And after learning of other existing administrative or judicial proceedings involving the child, communicating and cooperating with others to the extent and appropriate to protect the child's interests. The next section we will go over is California Family Code Section 3150B. Upon entering an appearance on behalf of a child pursuant to this chapter, counsel shall continue to represent that child unless relieved by the court upon the substitution of other counsel by the court or for cause. Family Code Section 3151, again, we'll start to repeat the same information, discusses the responsibilities of minors counsel, which we've already addressed, gathering, presenting evidence just as you would as any attorney in a court of law, expressing the minor's child wishes if that child desires that expression to be shared with the court, discuss the duties of minors counsel, interviewing the child, and reviewing court files. Family Code Section 3151, again, discusses serving notices and pleadings. Minors counsel shall not be called as a witness, discusses the rights of minors counsel, reasonable access to the child. This can be very tricky. Sometimes you're appointed into a case where the parent doesn't necessarily want to open their home up and doesn't want the child to be interviewed. And sometimes you have to go to the court and let the court know that you are being denied access to the child. That's one reason I like to visit the child in a neutral location, such as a school, so I don't have to put the child through that stressful situation. Standing to seek affirmative relief for a child, notice of any proceedings or assert or waive privilege on behalf of that child, and request from the court a psychological or physical examination on your own request for order. Family Code Section 3152 states, minors counsel upon notice motion to all parties and the local Child Protective Services agency may request the court to authorize the release of the relevant reports or files. In-camera review by court to determine if it should be released to minors counsel. And if it is released to minors counsel, that does not constitute a waiver of confidentiality. Additionally, I have included some relevant judicial counsel forms that might be useful to you. Family Law Form 322, Declaration of Counsel for a Child Regarding Qualifications. That is the form that needs to be turned in and filed with the court no later than 10 days after the appointment and before you can commence your work on the case. Family Law Form FL323, Order Appointing Counsel for Child. The Judicial Council has prepared an order that Riverside County does use, listing the rights and responsibilities as well as compensation for minors counsel services. And that can be found on our court website under Judicial Council Forms. And also very helpful and often overlooked is the FL323 info sheet. It's helpful to attorneys, it's helpful to parties, it's helpful to schools. And that info sheet does discuss what the rights and responsibilities are regarding the attorney for a child in a family law case. There are some additional statutes and code sections that you can look at in your free time. The Welfare and Institutions Code, Section 827, Evidence Code, Section 954, Evidence Code, Section 765B. It says Evidence Code, Section 3042, but that should be Family Code, Section 3042. That's about a child's right to testify in court. California Rules of Court Section 5.250, California Rules of Court Section 5.235, and the Probate Code Section 1470. There are some relevant cases that we will be discussing. In Ray David C., 1984, while counsel for child must consider child's preferences, they need not follow when not in the child's best interest. This is one of the more challenging aspects of being a minor's counsel when your client advises you that you represent them and they want to live with one party, but you don't feel that is in your best interest. A lot of times that creates some sort of conflict or tension between the attorney and the client. You can easily just affirm to the client that your role is to present the best interest of the child, and if you feel it's appropriate, you will also convey the wishes of the child as required and let the judge determine what would be the final outcome regarding the child's interests. Carroll versus Superior Court. An attorney may not continue to represent multiple minors among whom there is an actual conflict of interest, and when an actual conflict arises, attorney must be relieved from representation of any of them. So this happened to me at one point in time where I represented 3 minors. A teenager wanted to live separate and apart from the younger minors, and the younger minors wanted the teenager to continue to reside with them. At that point in time, I had to let the judge know on an ex parte motion, because we had a hearing coming up, that there was a conflict and that I would need to be removed from representing any of the children at that point in time. In Re Richard E., when a child's interests are not protected by contesting parties, court must appoint counsel for a child. And so if the court doesn't have faith that either parent or either attorney representing the parents are really putting forth what is in the best interest of the child, the court can appoint minors counsel to have that voice be heard in court. In Re Marriage of Metzger, the Court of Appeals in California determined that the appointment of minors counsel in a child custody and visitation case does not violate the constitutional right of a parent to determine what is in the best interest of their minor children. And there is a state bar formal opinion. It's not non-binding, but it does state attorney representing parent in custody dispute may not recommend that attorney be appointed for a child without consent of their client. Again, there's an indication that if your client is not able to represent the best interests of the child, that's the purpose that minors counsel gets appointed. So it's always very good to discuss that with your client ahead of time. And again, this opinion was advisory only and did not bind the state bar.